So what does an exclusion clause look like? This one comes from a trust deed. I just picked it up out of nowhere in particular. So, your screen isn't working. Let me read it. So clause straight out the middle of the document, 8.3, limitation of liability. Quite a standard thing in contracts that are written by lawyers is you'll find that you see a whole heap of proper nouns where you wouldn't normally see a proper noun in a sentence. So you'll see that where the word trustee and trust is used in this, that they're used with a capital letter. That generally signifies that those terms will be defined somewhere in the agreement. So there will usually be a list of definitions. Often you'll find it at the very beginning of the document. Sometimes you'll find it at the end. It usually appears under a heading which might be interpretation. It might be defined terms. It might be glossary. There's no particular term of art to it, but it is quite a common way of doing things. It's not legal or illegal to do it differently, but it's a real convention with drafting. And I think if any of you swipe around and have a look at the some of the standard agreements in the Encyclopedia of Forms and Precedents, just pick up a contract there. You'll see it's quite usual to have a list of defined terms. So the trustee is presumably one of the parties to this contract. And so just using that word trustee will be shorthand for Equitable Trust Partners, ACN 123456789, of such and such an address, blah, blah, blah. And the trust will be a defined term relating to a particular trust. So the Nolan Family Trust settled on XYZ dates, providing for billions of dollars to be settled on my children. So, what does the term say? Trustee is not liable for any loss arising from its administration or management of the trust other than a loss attributable to the dishonesty of the trustee or the willful commission of an act known by the trustee to be in breach of the trust. Small t there. Could be a mistake, could be a reference to the trust deed. Pretty sloppy drafting if you ask me, but hey, sloppy drafting happens a lot. So, what does that mean? Trustee is not liable for any loss arising from its administration or management of the trust other than a loss attributable to the dishonesty of the trustee or the willful commission of an act known by the trustee to be in breach of, let's say, the trustee. What does that mean? Can you put that into language that you could advise your client what it means? Yeah, Sarah, I can see, you know.
If anything happens in life, in the world, that's something you do, the only thing I'll be liable for is what I specifically do that's wrong.
Basically, if you suffer any loss because of the way that I look after the trust fund, I'll only be liable to compensate you for that if I've done it dishonestly or I knew it was in breach of the laws, which is sort of another version of dishonest, really, isn't it? So accidental slip-ups, not included. This happens quite a lot too, that the exclusion will be coupled with an indemnity. So we spoke a bit recently about the difference between a guarantee and an indemnity. And that idea that an indemnity is really just holding somebody in the same position regardless of what goes wrong. So here it says, provided the trustee acts in good faith. A whole lot of law about what good faith might mean. The trustee is entitled to be indemnified out of the trust fund for all debts, damages, obligations or other liabilities incurred arising or awarded by or against the trustee in the execution of any power, duty, discretion or authority under this deed and in respect of all actions, claims, demands and costs relating to or concerning the trust fund. In shorthand, if something goes wrong, the trustee is not going to be out of pocket and he's going to look to the trust fund for compensation. Trustee is entitled to reimbursement from the trust fund for all monies expended and debts incurred in or about the administration of the trust, and it may apply the trust fund or any monies or properties comprised in the trust fund as it may decide to satisfy the rights of reimbursement or indemnity which it is under this deed or otherwise by law entitled. In other words, I'm not going to compensate you for anything that goes wrong unless I'm somehow acted dishonestly or knowingly breach the rules. But in any other circumstance where something goes wrong that I'm out of pocket, you're going to pay me. Not a particularly unusual clause. Here's another one. You've probably seen ones like this quite regularly. This is an American one. We can tell that because it's in shouter caps, despite the fact that there's plenty of science that says these are harder to read than actual proper language. There are rules under the various US codes that require these kind of clauses to be put into capital letters. And the reason for that is to bring to people's attention that they're important, but it's kind of counterintuitive because you know it's important, but you get bored halfway through reading it because it's hard work if you don't read them properly. So, in no event will a company be liable to you for any lost profits, lost savings, or incidental, indirect, special, or consequential damages arising out of your use or inability to use the product or the breach of this agreement, even if advised of the possibility of such damages. Some states do not allow the limitation or exclusion of liability for incidental or consequential damages, so the above limitation or exclusion may not apply to you. So this is clearly a clause that's sitting probably in a software agreement somewhere. Somebody's downloaded. So when we spoke last week about consumer contracts and we were looking at the range of statutory guarantees, they included that there was a guarantee that the goods would be fit for the purpose that you've advised the vendor of. So this is seeking to exclude that. It's saying we're not going to be liable for anything that goes wrong with you, even if we're advised of that particular thing that you need it for, or that particular risk. We're just not liable, unless the law says this isn't enforceable, in which case it doesn't apply to you, it only applies to other people. This is a pretty common approach, and that's why I've used it as an example. Questions, thoughts, observations? Don't worry, you won't have to interpret clauses in your exam or anything. I'm just trying to set some context here for what it is we're talking about, because you will see these kind of clauses a lot.
But you know, I could be wrong. I feel like I've read somewhere that you can't sort of write in a contract, write yourself out of the action of court.
That's a good point, actually. It's a couple. I thought you were going to go somewhere else with that question, but that's all right. And it's, the other thing, remind me the other thing when we finish talking about this, because it's probably a point worth making too. You know, you're right. We've actually spoken earlier about this idea that you can't exclude the jurisdictions of the court. Ultimately, whatever liability you will have, if you don't agree it with the other party along the way, will be whatever the court says you're liable for, based on its interpretation of the contract. So a court will need to interpret the whole of the contract, taking into account a liability clause or an exclusion of liability clause. So if the common law says, if there isn't a statute that excludes this, then this clause is part of the contract. You know, assuming all of the other elements are there, that we've got, shall we say the mantra one more time? Agreement comprising offer and acceptance, but if you can't find them, consensus ad idem, a meeting of the minds, consideration, intention, and certainty. Well, if we have those things, we have a contract. If once we know we've got all of those things, then the question is there a formality that impacts that? If there is, well, it's going to be satisfied by the document, I guess, so it's probably unlikely to be that kind of issue. And so then we go to the question, well, what are the terms of this contract? So what are the terms of the contract? We can gather them from the written instrument. It then is a question about whether there are other express terms in addition to the ones in the written instrument. If it's clear from the terms of the instrument that this is an agreement that is partially made in writing and partially made by other things, then it's easy. We look at those other things, we've got the record of the conversation, that's fine. If it's not, and even if it is actually to an extent, the parole evidence rule steps in. So the parole evidence rules essentially says, I don't know, this is not a way I would quote it in your exam if I were you, but writing trumps our memory of what was said. If they're inconsistent, the parole evidence rule actually stops us from bringing evidence in that is inconsistent with or varies what's in writing. So we either need to argue that the contract wasn't entirely in writing, this additional information is in addition and isn't inconsistent, or we have to exclude it in some way. So we've been through lots of those. So we've got an agreement, we're at that point. Next question is, now we've identified all of the terms, they include this term, so what does it mean? Is this term enforceable or not? So the common law basically says, well, and what, 2 slides ago, is the clause part of the contract? Tick. Is the party relying on it privy to the contract? Tick. Then the clause will apply in relation to the dispute. But what that means, how it will be read, will come down to what a court says. Is that helpful? A little bit?
I'm guessing there'll be more.
Oh, yeah, there's a few more things. But we'll get there. The other thing that I thought